Well, hello, everybody. Justin Owen here with the Beacon Center. I want to welcome you to our conversation about ESAs, in particular, the lawsuit that you all are aware that is happening, and the hearing that we had yesterday on the issue, and talking about just what that means, what the path is going forward, and how that impacts parents across our state. I want to first welcome our panelists who will be joining us for a conversation after we watch a short clip from yesterday's hearing. We have the three organizations who have sponsored today's discussion, led by the American Federation for Children, Shaka Mitchell, the state director there. Shaka, thanks for joining us. We also have the Institute for Justice, who is part of the litigation yesterday, and Keith Neely is joining us with IJ. Thank you, Keith, for joining us. And then also part of the litigation yesterday is my fellow Beaconite, Braden Busek, our Vice President of Legal Affairs. Braden, thanks for joining us as well. Well, we're going to dive right in and watch a brief clip of yesterday's hearing. We're not going to make you watch the whole thing because it was almost an hour and a half long. And being a legal argument, it was very dry in parts. And so we tried to pull out some of the more important segments, some of the more important discussions related to this. But keep in mind, again, it's still a legal argument. There may be parts where you go, I have no idea what is happening or what they're talking about, but that's why we're going to have a panel discussion immediately after. So about a 9-minute video, and then we're going to welcome our panelists back to have a little bit of a discussion about it. If you have questions when you are watching the video, you can feel free to type those into the chat function at the bottom of your screen on Zoom. Or if you're watching us on Facebook Live, you can actually just post those in the comment section, and we'll do our best to get them as much as possible. So when we watch this video, again, it's about 9 minutes. You're going to see a few people making arguments for and against the ESA program. In favor of it, you're going to first hear from James Newsom, who represents the state in the Attorney General's office. Then you're going to hear from Arif Panju, who is with us, is with the Institute for Justice, also on our side. You're going to see Brian Kelsey, who is with the Liberty Justice Center, making some arguments. And then on the opposition, you're going to hear from Bob Cooper, who represents Nashville and Shelby County, who has sued to challenge and attempt to strike down the ESA program. And so with that, let's take it away and watch a brief video.
Metropolitan Government of Nashville and Davidson County et al. Versus Tennessee Department of Education et al. Tennessee is now in session.
The means by which the General Assembly's constitutional obligation to provide educational opportunities to Tennessee's school children is a legislative prerogative. The responsibility for education is upon the LEAs, or the local educational agencies, and not the counties themselves. And so what has, as in accordance with the ESA program, there is no additional burden that is placed upon the municipalities by virtue of the ESA program. A school system, like a highway system, a penal system, or public health, is not of purely local, but of state concern.
To fall within its scope, a challenge law has to act upon a county as a county entity. In other words, a law must impact the nuts and bolts of what makes a county a county. And this term of art has consistently been applied regardless of whether or not a law impacts a county's finances. The court did not delve into any inquiry into what kind of impact on finances took place. In fact, not a single time in the entire jurisprudence has any Tennessee court delved into an impact on finances to determine whether a law was applicable in the governmental or proprietary capacity. And if you look at successful home rule amendment claims, you see cases like Ferris v. Blanton, runoff elections, which directly impacts the nuts and bolts of county government, who will hold the levers of power. First Utility District of Carter County v. Clark, appointments to commissions. Well, yeah, that affects the nuts and bolts of who's going to sit in those commission chairs and make decisions. Durham v. Dismukes or Lawler v. McCandless, expanding the jurisdiction of county courts, which impacts a county's power to adjudicate legal disputes, is not the type of law that acts upon the county within the way that it operates county government. It's not about appointments or elections. It's not about someone stepping in and acting on behalf of the county. This is a benefit program for direct benefits to Tennessee citizens. Yeah, mere impacts on a county's budget are not sufficient to satisfy the second part of the Home Rule Amendments inquiry. That's correct, Ron?
In terms of the counties themselves, the answer is it doesn't affect them at all. They have no injury, in fact, and therefore they lack standing to bring this claim. What the counties have that they talk about in their brief is they simply have an education mandate, not an ESA mandate, an education mandate. They have to pay the local portion of the BEP for every school-age child in the county. Because the policy decisions about education are not what's left to the counties. It's the funding that's left to the county governments, the funding only. That's their role in the so-called partnership that they claim about. So the only injury that they can claim is to the part of the role that they've claimed, which is their funding. And that's not an injury to their funding. What happens to the money after it leaves their hands, that's up to the legislature to determine what is education policy and how is it best spent to educate these children. At least for the first 3 years, that the school districts get paid a second time for the same child. There's an extra reimbursement. We call it a ghost reimbursement for another child who's not there. And so they get extra money for 3 years paid for by the state.
The ESA Act applies only to Davidson and Shelby counties now and in the future. It takes their money to send their students to private schools, and it does this without the county's approval. The chancellor correctly held that the ESA Act violates Article 11, Section 9 of the Tennessee Constitution, the Home Rule Amendment. Now, many of the objections that you've been hearing and reading to the chancellor's ruling, both on standing and the merits, are based on one assertion, which is that the act has no effect on the counties. That argument takes several forms, that it applies to LEAs, not counties, that the counties can show no budgetary injury, that the counties aren't required to do anything or to fund anything. But this court should follow the guidance by the Tennessee Supreme Court in Ferris v. Blanton and look beyond the rhetoric at what the act actually does. Under the ESA Act, the state will give each participating student an annual amount equal to the average state and local per pupil funding under the basic education program. Then the state takes the full amount of that award, both the state and local shares, out of the money it would otherwise pay to the school district. In other words, what the state gives to the student, it takes back from the school district. So funding these accounts is not going to cost the state a dime, but the school districts will be left with a huge deficit. As the court has already pointed out, the grant program is an unfunded mandate. You've also pointed out the grant program only lasts for 3 years, whereas the ESA Act is perpetual.
So what is your position on the language applicable to a particular county as whether it includes 2 counties or not?
And the ESA Act's effect on appellees is clearly substantial. Again, you can just look at the fiscal memorandum for a start. Now, Your Honors, at this point, it should be clear that appellee counties have standing to assert this claim. The counties will suffer a distinct and palpable injury. The ESA Act will cause that injury, and the Home Rule Amendment provides a judicial remedy. All the criteria for declaratory judgment standing have been satisfied. This is not a complicated case. The ESA Act applies to only 2 counties, and it has a substantial effect on those counties' finances and sovereignty. If the state wants to take over providing public education in Tennessee, it wouldn't have to worry about the Home Rule Amendment. But it has enlisted local government to play the primary role in education, so it must treat local governments equally or else get local approval. This is a case for which the Home Rule Amendment was designed for. The Chancellor correctly held that the ESA Act is unconstitutional under the Home Rule Amendment, and we respectfully ask this court to affirm the Chancellor's judgment.
It is the county's obligation to fund the LEA. The ESA does not affect the county's funding obligation. It is revenue neutral.
Something that's also noticeably absent from Metro's presentation is any explanation for why this court should ignore the plain text of their charters, which expressly prohibit them from interfering with educational options, county education funds, etc. They don't have the power to do so under their own charters. And Shelby's charter was promulgated pursuant to the Home Rule Amendment. The ability to interfere with educational options is outside of their governmental and proprietary powers that are contemplated under the amendment. And they make no effort here at oral argument to dispute that. Paragraph 5 of the Home Rule Amendment says that charters provide for the governmental and proprietary powers of a county. They don't have the power, which is why they have to advance an effects theory to do an end run around their own charters. This applies directly to the constitutionality of the statute because it makes clear that the ability to interfere with educational options, direct benefits, do not extend to the governmental and proprietary powers that the Home Rule Amendment contemplates. These are direct benefits. Those limits enshrined in the charter should be given full force and effect. They were put on paper and authorized by the voters in those jurisdictions to do exactly what they're designed to do, impose limits. And that has to carry weight in the Home Rule Amendment analysis because the counties are trying to trigger the amendment to extinguish the very educational benefits that the charters prohibit them from interfering with. That has to inform the analysis here, Your Honors.
Again, on this funding issue, as we said, for the county, the funding is the same, but their interests diverge from the school district, which actually wants more money. The county wants to pay less money. The school district wants more money. Well, they get it with this bill. And I would point, Your Honors, to this left behind windfall. It's the first one that we mentioned in our brief. It lasts every year going forward, and it's up to, according to the record, $4,000 out of the $12,000 or $13,000 per student. $4,000 is left behind in the school district for each child that gets the ESA. So they should want even more students to take it. They benefit from this. Therefore, there's no injury in fact and no standing.
Well, thank you, Shaka, for running us through that video, and welcome back onto the screen. So again, I have Shaka Mitchell with American Federation for Children, Keith Neely with Institute for Justice, and Braden Busek with the Beacon Center. So let's talk about what we heard, what some of this actually means, because it is a little technical, a little wonky. By the way, if you do have a question as we're having a discussion, you can chat it here on Zoom, or if you're on Facebook Live watching, put it in the comments. With all this talk about counties and home rule, Braden, I'm going to kick it to you first. What is at stake here? We didn't hear a lot about ESAs themselves as much as this notion of counties and home rule. Can you explain specifically what was being heard by the court yesterday?
Well, I think that the localities are arguing that they've got a certain measure of local sovereignty that they're entitled to, and that emanates from the Home Rule Amendment. Under that Home Rule Amendment, they're entitled to not be singled out as a matter of state law unless they are given the option of voting for the state law in question, which in this case is the ESA program. But the subject matter, of course, is the state's desire to provide an educational lifeline to children who are in the biggest school districts and in chronically underperforming schools.
Yeah, we heard a lot about money as well. So a lot of this hinges on that. At one point, Mr. Cooper said, this is their money, referring to the county governments. Keith and Shaka, I'd like for you both to maybe, what's your reaction to hearing that this is their money, the government's money, not money that should be given to parents and spent as they see fit? Keith, you want to go ahead?
Sure. Well, it kind of describes the county's motivation in a nutshell, and it kind of shows how far afield their legal claim is. For them, the parents and students who have the right under the ESA pilot program to take that money and go use it at a school belongs not to the students and parents, but to the counties. And that's why they want to interpose themselves in this lawsuit, to prevent those students and parents from exercising that choice, because they're concerned how it affects them. But they're not concerned with how their schools have been underserving and underperforming now for decades. and who have been leaving these students and parents without an opportunity to receive an effective education. So it was kind of a shocking statement to hear it in oral argument, but it describes exactly where they're coming from and how far afield their view is of this law, how outside of the realm of the ordinary, outside of the realm of what this law was intended to do. It's kind of a rather shocking admission during oral argument.
Yeah, and I would add, I think, and this isn't so much a legal claim that was made yesterday in the arguments or in the briefs necessarily, but I wrote down that same phrase, Justin, their money that was used. And I think that it's a real tragedy, and it's also very telling that the county seems to be paying, whether it's Shelby County or Metro, Nashville, Davidson County government, seem to pay an awful lot of attention to how these dollars are spent on the way out versus paying that much attention to how, combined, these two cities spend $2 billion a year on education. And for the past, 40 years, they haven't paid a lot of attention to how that money is being spent. But boy, they really want to hold on to those dollars. And that, I think, is very telling.
What they also don't mention is that child is leaving the district and is no longer being educated by the district. They don't have the cost of educating that child. And even if you admit there may be some fixed cost associated with that, as Senator Kelsey mentioned in his argument, you're looking at $4,000 per child when a child leaves the school. Doesn't this potentially save districts money or make them money when a child leaves? When do you want to address that piece of it as well?
Yeah, I'll jump in very quickly. It absolutely does represent a savings, and you heard that a little bit in the video snippet that we just heard. But I would also say, just on kind of a common sense, from a common sense standpoint, this is not different from what happens every year in Nashville, which is once parents have school-age children, they move across the county line and they send them to school in another district, right? This happens in Shelby County as well. They move, you don't even have to leave the county. You can stay within Shelby County and go to Germantown schools or Arlington schools, right? Parents find a way. We don't say as soon as you have children, you're locked into that public school zone based on your zip code for the rest of their lives. No, parents have a choice and they're able to move freely so that they can find the best education that works for their student.
Braden, I want to ask you another sort of more legal question. They seem to emphasize this notion of this money can only be spent on public education. It can't be taken by parents and sent to a private school. Is that even at play right now in where we are in the litigation? And even if so, what has the result of that kind of thing been in other states that have similar school choice programs?
Repeat the second part of your question.
Nationally, in other states where there has been litigation on this, what have some of those results been about saying that you can't take taxpayer money and let a kid go to private school with those dollars?
Constitutionally speaking, this is not a new argument, and by and large across the board, the courts say that school choice is a constitutional way of addressing public education. To go to the second part of your question, some of the most rigorous school choice exists in places like Florida. And as I understand it, the best available data shows that there really is not a net savings or a net loss to even the public school districts that lose the greatest number of children. And conversely, they tend to show the highest rate of improvement when they start feeling the effects of competition.
Very good. Keith, anything to add to that? I know the Institute for Justice has litigated this issue in numerous states over the years. Again, as Braden said, it's nothing new that they're trying to do here. Anything to add in terms of your perspective on this type of litigation and challenges to school choice programs?
Well, I think it kind of illustrates how far school choice programs have come legally over the years. You know, as you alluded to, and as Braden alluded to, these challenges aren't new. And for decades now, organizations like the Institute for Justice have worked to litigate these questions before the US Supreme Court, and we've won those cases time and time again. And now they're not challenging the federal constitutionality of this program. They're trying to look at smaller and smaller provisions in state constitutions like Tennessee's and like the Home Rule Amendment, trying to throw everything but the kitchen sink at these programs to try and sink them. So, you know, it's a new challenge for us in that, you know, these types of Home Rule Amendment challenges haven't been as common or as frequent over the years. But I think it's an exciting sign of progress that that's where we are now, that, you know, so much of these programs is now settled law, and now we're dealing with, you know, newer and smaller challenges. And so we're excited to win these types of cases as well.
One of the things that is apparent in this is that the plaintiffs are the city of Nashville and Shelby County, because they are the two school districts that this applies to. Shaka, you were involved in the legislative efforts on this, so you'd really have a good perspective on it. Did the legislature just pick on Memphis and Nashville, say we don't like you, so we're going to, you know, impose this program on you? What was the rationale for the legislature to say it applies in these two school districts?
Yeah, it's a good question, and it comes up, and I think it's a fair one when people ask, well, why that? I mean, we actually get the question a lot from parents who are outside of those two areas. They say, hey, when is it our turn? You know, because they're eager to use this type of program. But I would say, you know, consider this is Tennessee's second education savings account program. The first education savings account program, is, as you all know, is limited to students with exceptional needs, and only a certain list of those too, right? So this is the second program, and it's also the second program that is somewhat limited in scope. That's legislative prerogative to identify a problem, say, all right, let's try to work on this problem. Let's come up with a solution and see if it works. And in the case of Nashville and Memphis, I would say two things. First of all, between these two counties, you're talking about somewhere north of 20% of all students in the state. So so we didn't pick, you know, Dyer County and, you know, another sort of Lake County, another far-flung sort of county with very low populations. This is over 20% of the students in the state could be affected by this in terms of geography. The second thing is, if you look at where the highest concentration of low-performing schools are, it's not even a question. It's these two cities. It is possible in both cities for a student to go from kindergarten through 12th grade at a bottom 5% school.
Wow.
That's unconscionable. So if you're looking around if you're a legislator, a policymaker, and saying, hey, where are students who need help now, today? I think it's a no-brainer that you would go to one of these two counties.
Without a doubt. Well, one thing back on the legal aspect of it, and Braden, you can probably address this the best. Arif mentioned in his portion of his arguments that even if the counties were successful at advancing this argument, their charter prevents them from interfering with this right of parents anyway. And, you know, Memphis and Nashville, or Shelby County and Nashville, both have a charter that the voters have agreed upon. Can you explain a little bit more, maybe in layman's terms, what he was saying there? That sort of the counties are trying to do something that they don't even have the authority to do in the first place.
Yep, separate and apart from whether education is predominantly a state or local responsibility, the two cities in question, Shelby and Memphis, have their own city charters. And pursuant to the authority of their own city charters, they have pretty much walled off the school boards and the school board districts from their general scope of authority. So I think the point that we were trying to make is this has caused the localities to have to resort to a pretty far-flung argument about how they're impacted by a school choice law which by its own terms only applies to these two school board districts and the Achievement School Board District. And that argument is that there's this knock-on effects that indirectly affect their funding. And that's therefore how they're injured by the ESA law.
Thank you for that. So procedurally speaking, we are sort of at the mid-level of 3 levels potentially. We had the trial court, Davidson County Chancery, where the chancellor ruled that the program was unconstitutional on this home rule provision that Braden explained at the outset of the conversation. There's the Court of Appeals, which is step 2. That's what we heard yesterday in oral arguments, and you saw snippets of just a few minutes ago. What happens next, and what's the next step, win or lose? If the 3 panel of judges that we saw on the video, if they side with parents and in support of school choice, what do we expect to happen at the next phase? And whoever wants to answer that.
Yeah, I'm sure that whoever loses will ask the Supreme Court to accept review, and that's where the final word will be had on the constitutionality of the home rule amendment. We're hopeful that the Supreme Court sees things our way and reverses what happened down below, and does so in time for the ESA program to be instituted prior to the 2021 school year.
So in all likelihood, this is going to wind up before the state Supreme Court one way or the other. And the goal is, as you said, Braden, would be that get that done in a timely fashion so that parents can make decisions for the 2021 school year. What was the interest in this? And I'm about to wrap up and open it up for Q&A. I know you have a few questions, but what was the interest among parents in this, Shaka? You've done a lot of parent outreach on this before the trial court prohibited the state from moving forward with the program. What kind of interest was there from parents?
Yeah, I would say there's pretty significant interest. And keep in mind, the application for the ESA program opened, in what was a pretty crazy spring, right? Here in Nashville, we just had a tornado the week that the application opened. 2 weeks after that, the state began safer at home and stay at home mandates because of COVID-19, right? So it was disruptive. I don't think there's been anything like it ever. Nevertheless, more than 2,500, I believe north of 2,700 students signed up for the ESA program. Again, in what was a really disruptive time. This is when families couldn't even go and visit schools, right? Because schools had shut down. So I think there's pretty significant interest. I think there will be. I think I wouldn't be surprised if we have a question about this, but now post-COVID, I think interest is going to be through the roof because you got parents trying to figure out lots of different ways, but I'll save that for the questions.
Very good. Well, we're going to open it up to questions now. If you do have a question, you can either click on that chat box down at the bottom of your screen on Zoom and type your question in the box that pops up on the right, or you can, if you're on Facebook Live, just type your question into the comment section. We did get a question or two in advance. So I'm going to look at this one is fairly long, so I'm going to try my best to restate it properly and succinctly. But we got a question particularly about the original ESA program for children with special needs. And Shaka, I'm going to ask you this one. The question effectively asks, why not force those private schools that accept children under that program to comply with the same standards as the public schools with their Individuals with Disability in Education Act, other factors that public schools have to follow? Why not apply those same standards to the private schools that these parents are choosing to send their children to?
Yeah, I think, without trying to relitigate that entire program, there are two big differences, or frankly, one big difference between a private school and a public school. And I think it comes down to what I would call true accountability. in a private school context, if I as a parent feel, and I am a parent, if I as a parent feel like one of my students is not receiving services that meet his or her needs, well, I can leave, right? I get up. That to me is real accountability, is when you can sit across the table from a principal or a teacher and you can say, this is not working for us. We're going to go do something else, right? You don't really have that. That same accountability doesn't actually exist in the public school system. That's why we have the IDEA. It's so that we can check the boxes to say, oh, are we checking all these appropriate boxes to serve students with special needs? And I would say right now, and I'm not sure where the person who asked this question is from, but school districts across Tennessee have started up this year. And I actually genuinely worry about our students with special needs right now and how they're going to be served by districts that are not doing in-person school or some sort of hybrid. I mean, what options do those parents have, right? They may be, if they lack resources, they may be without any meaningful choice to add educational value for their kids.
We did actually get this is a good follow-up, because we did get a question about this sort of, how has COVID impacted this? And Keith, I'll ask you, what is the national appetite you're seeing for different types of choice? And it may not be just a traditional ESA type, I'm going to take the funds and send my child to a private school. Maybe it's micro schools, pods, online learning. What have you seen nationally? And I know, Shaka, you said you had some thoughts on this too, so I'll bounce it back to you in a minute.
Yeah, as you alluded to, there's a lot of interest right now for parents who are seeking alternative, safer ways to obtain an education for their children in a time of great uncertainty. I mean, even here locally, I'm based in DC, and there's issues right now just across the river in Montgomery County in Maryland, where you have a county official there who's trying to prevent private schools from accepting students and from teaching them in person until after the 1st of October. But they're not doing it in a case-by-case way. They're doing it in a broad, just we're going to shut the door on the system kind of way. And parents are understandably upset, because for many of these parents, just as it is in Tennessee and in other places across the country, I mean, these programs are a lifeline. And when you take that lifeline away, parents don't really have an option to send their children to an acceptable public alternative. So I really think you're seeing, with COVID, an opportunity for these, cutting edge educational options to flourish. And state and local governments can either stand in the way of that, or they can help support that as best they can. And the governments that are supporting it are the ones who are going to be seeing the most success down the road.
And Shaka, do you think that policymakers themselves will view this differently, state legislators and others who are making these decisions?
I do think they'll view it differently. I mean, I think that both from a student kind of centric angle, which is our lens, we always ask the question, is this best for students? But I think about in this context, in the COVID context, about many faculty members, teachers, right, who may have health issues that limit their ability to be in a physical school building with, hundreds or thousands of kids, but they're great educators. Well, wouldn't it be nice if we can match some of those great educators with kids who need, to maybe also learn at home or learn in a smaller setting, et cetera. And an ESA provides that kind of flexibility so that you can kind of custom tailor the learning scenario to your situation. So I think there's going to be interest for a number of reasons, and it's why we just don't believe that one size fits all.
And going back to yesterday's hearing that ties to this, Braden, one of the arguments we kept hearing was, this is the role of the locals, the opposition at least, that this is the role of those local governments, not the state. But we made it very clear that it is our opinion that setting the policy for the state is the role of the legislature, and setting policy for education is the role of the legislature and the state. Can you hit on that a little bit from a legal standpoint as it pertains to yesterday's hearing?
Well, that's absolutely right. And by dint of Tennessee's constitution, Tennessee is required to maintain a system of adequate public schools. Tennessee has entrusted a great deal of that authority in the local governments, but particularly vis-a-vis Nashville and Shelby County, they've done a pretty poor job. And the ESA program was the most innovative and creative and forward-thinking program that the state has ever undertaken to remedy that situation. It's unfortunate that the localities saw this as an opportunity to inject themselves and stand between a parent, a child, and a quality education.
So a question we got, do we anticipate at any point this program in particular being expanded beyond Shelby and Davidson County? I know our organizations would certainly support that because we believe that choice shouldn't stop at borders within the county borders, within the state or district borders. But Shaka, you want to talk maybe about what is, tying it back to what you were saying earlier about the change in the appetite, is that possibly part of that here, that this program itself could be opened up to more families in the future?
Yeah, I think there's certainly it's hard to answer this question, with pure objectivity, right? But because we view this as a benefit that could be applicable to any family and to many families. But something that I think is really important to say is just because there is an education savings account, an ESA, it doesn't force people to use an ESA, right? So other states, you mentioned Florida earlier, that have a tax credit scholarship program or has a voucher program. If there's a voucher program, it doesn't force people to use a voucher. It just gives people who need an option, it provides them one. So homeschooling is already legal and available to any family in Tennessee that wants it. Homeschool numbers are probably rising, exponentially right now. It's an option. It's not, we would not force any parent to do something that's not in the best interest of their kid, but we want to make sure that they have that choice.
One question we got is, and these programs aren't untested. Like Braden, you mentioned this earlier, it's nothing new. Keith, can you talk about some of the programs nationally that have been in existence for far longer than we've even had here in Tennessee?
Sure. I mean, as Braden alluded to earlier, Florida is often cited as kind of a, landmark example just because of the breadth of the programs that they have there. But even when you go beyond Florida, there was a study that IJ, the Institute for Justice, pointed to in its most recent publication of 10 facts and myths about school choice. And it collects studies that have been done on all of these various school choice programs around the country. I believe some 16 or 20 in total. And it found that in virtually every single case, the programs either saw an improvement in the quality of local education or were neutral. So you didn't see programs that adversely affected students in public schools, as the counties always like to claim. So, whether, as Shaka was just discussing, whether folks want to use the ESA program or not, I think the result is a better education for all parents and students, because what you see is an element of competition. They actually have to work to show why what they're producing, the value they're adding in education, is worth it to that family and that student, and it empowers those folks to make decisions. So this isn't a new policy area. We've had programs within the United States doing this now for upwards of 20 years, and they've all shown success.
Very good. That's helpful perspective nationally, that this is nothing new again. And hopefully we'll be joining those states with an expansive program soon. So a couple of final questions. We're about to run out of time, but we've got a couple of things. I'm going to end on a couple questions that tie together about the ruling and next steps. But specifically first, there's a lot of talk, speaking of nationally, about federal action on this. That I think the Senate, the HEALS Act, I believe it's called, includes some type of potential scholarship for families. Shaka, you want to talk a little bit about what you might see from a federal standpoint on choice as well?
Sure. We're keeping an eye on this, and the Senate version of the next Relief Act, and we expect some kind of Relief Act to come from Washington, D.C. Related to COVID. We expect, well, it's our hope, I should say, that whatever comes in the form of legislation does include something that would be a direct payment for families, a direct benefit for families whose children's education is negatively impacted by this, right? And that could take a number of different forms. There was actually a piece of legislation that was put forth by Tennessee's own senior senator, Lamar Alexander, last week, and he, along with senator from South Carolina, and it would do just that. It would give parents more ability to select the school of their choice, right? And again, if no one uses it because they think that their neighborhood school is just working so well for them, then fantastic. Then we'll save a bunch of money and we'll learn something. But however, as we think about how we keep kids on track and learning right now, I think this would be a really good option. So we've actually got something, I think it's probably on our Facebook page. If you want to learn more, you can learn more at the Tennessee Federation for Children's Facebook page.
Very good. Thank you for that. So as we wind down, I want to go back to more of the procedural, where things stand. So yesterday's hearing that we watched earlier was at the second of likely three steps of this at the Court of Appeals. At the next step, we, win or lose, we think either way that this will probably wind up before the state Supreme Court. Braden, this was a final question from Facebook for you. Did the judges give a time frame for a ruling? Are they bound by any time frame? Do we have a sense for when we might have an answer at this stage relative to yesterday's hearing?
No, there's no crystal ball, and the judges are bound by their own schedule. So it's whenever they feel like they've digested the issues capable of issuing a ruling. We're hopeful of a quick resolution. I'm sure the judges are all aware of the intense public importance of this case and will do their best to dutifully issue an opinion.
Very good. Thank you. Any final words? We've got 1 minute left. So anything we didn't cover that you'd like to hit on very quickly? All right. Well, thank you to our all-star panelists for this great discussion. We appreciate everything you've done on this important issue for families across our state. And thank you to those who tuned in to watch today and to learn more about this issue. We hope you'll stay engaged because this is important. We're talking about our future generation, and we need to do everything we can to make sure they get the best education possible. So again, special thanks to IJ for co-hosting today, and particular American Federation for Children for being the main host. We appreciate all you do, guys. Have a good one.
Thanks, Justin. Thanks, guys.